Abatement insurance, also called enforcement insurance, is for IP holders who might become plaintiffs in a lawsuit, enforcing their intellectual property rights against alleged infringers. The insurance provides funds and services to enable policyholders to more effectively negotiate, enforce, and protect their IP rights in the marketplace. There are several strategic reasons to carry intellectual property enforcement insurance. To strengthen the negotiation position and licensability of intellectual properties. To provide enough funds to support a strong legal front, thereby increasing the likelihood of a favorable outcome. To make funds available when necessary, rather than utilize operating capital or attempt financing. To limit the risk of unsuccessful litigation through more informed decision-making. And it does include IPISCs, litigation management, and early intervention services. Enforcement insurance reduces the pressure to settle due to a limited resource of funds. It also discourages potential infringement by demonstrating the financial ability to enforce intellectual property. It prevents loss of market share by quick, decisive responses to infringers and makes your technology more attractive to investors considering your business. So, how does abatement insurance work? As the owner of a patent, trademark, or copyright, you invest in an enforcement policy. Time passes, then a competitor begins selling a product that you suspect infringes on your intellectual property. If the case can be made that the product does infringe on your intellectual property, we can first write a letter notifying the competitor of your IP and identify your financial ammunition for legal enforcement, our insurance. This is called our early intervention program and often results in licensing negotiations or termination of infringement. If the competitor ignores this notification, you would then consider bringing suit against him. In order to be sure, we will help you obtain a legal determination, giving you specific information regarding a suit. We can then help you find an approved attorney to litigate the case. We'll make sure you get an estimate of how much litigation will cost and have the attorney agree to specific billing guidelines. Upon complying with the policy terms, we will authorize your case. You and your attorney will have control over the lawsuit, including the negotiation of settlements. IPISC cannot force you to settle. During the course of the litigation, your lawyer will send invoices to you and us. We'll reimburse them periodically after deducting coinsurance and deductible portion up to the limits of your policy. If the suit concludes in your favor, you and IPISC will share in the economic benefit relative to the amount of money each has contributed to the lawsuit. However, IPISC's share of the economic benefit is limited to the amount we've actually expended, plus a small surcharge if you receive a large monetary settlement. Even better, any money IPISC realizes will simply replenish your policy limit. That means you can use the policy again to sue another infringer within the policy period. So, just a couple specifics about abatement insurance. It provides coverage for specific intellectual property, patents, trademarks, and copyrights, or foreign equivalents and applications as identified in your policy. It reimburses legal expenses in intellectual property infringement litigation. It has a copay and self-insured retention, which is similar to a deductible. It automatically includes our early intervention and litigation management services. It is a claims-made and reported policy. It covers infringement that begins during the policy period only. And again, the policy has an economic benefit provision. Anyone who has the right to enforce intellectual property, or will have that right once the intellectual property becomes enforceable, can apply for abatement insurance. IPISC offers policy limits of $100,000 through $5 million. The annual premium ranges from $2,000 to over $200,000 depending on the limits, number of insured IP, and relative risk. Please review the policy specimen in depth and consult with your professional advisor for all the details. IPISC has seen hundreds of companies benefit from the coverage. For example, one business owner forced two larger companies to take a license because he had the financial backing to enforce his rights. In another case, an infringer decided to license the intellectual property after learning of the insurance. In yet another case, the infringer took his product off the shelves before our insured even filed suit when he learned of the insurance. Bottom line, litigation is costly. The American Intellectual Property Law Association projects the cost of a suit at up to $5.5 million. IPISC pioneered the industry with the first ever abatement policy in 1989 and has been working with litigation risk for almost 20 years. Let us help you make the most of your IP.